advocates, so I am sure they will clarify what it really means. And this is today being a very important date because it's 14 to 14 is a rare event. If you read from left to right or right to left, it reads the same. And of course, we have some interesting 7 questions lined up by Dr. Anita, and we will have a very interesting session. Now I hand it over to Mr. Bhavesh Joshi for introduction and further event. Thank you.
Respected Chairman Shri Inamdar, today's paper writer Dr. Ms. Anita Sumanth, past President Shri Parikari, Joint Secretary of Chamber Shri Joshi, seniors and friends. A very good morning to all of you and wishing you all a very happy Valentine's Day. I see a lot of red and pink color today. And thank you all for dressing up in this color to bring alive the spirit of Valentine's Day. Yesterday, a chocolate cone was distributed to all, and our chairman Shri Vijay Bhatt announced that it was on the occasion of some of the delegates who are celebrating their birthdays and anniversaries during this 4 days of conference with us. And also that it was on occasion of Valentine's Day. He later on also added that. But friends, the implied meaning of this was that it is a small moment of appreciation to all of us who are celebrating this Valentine's Day without being together with our dear ones. I suppose that except for a few exceptions like our tomorrow's speaker Shri Pradeep Bhai, most of us are sitting here spending the Valentine's Day much away from our better halves, assuming that our better half are our Valentines. But one thing is sure, that the love is the essence of life and presence of a dear companion is a basic necessity of our life. Neither can you hug yourself, nor can you cry on your own shoulder. Life is all about living for one another. So live with those who love you the most. Maybe today you just saw this some presentation on investments and all those things. But one more thing is that relations cannot be understood by the language of money, because some investments may never give profit, but they make us rich. Once, a young lady went to a doctor. She said, doctor asked, what is your problem? She said, I have got an infection on my lips. Doctor examined and asked her, तुमने कभी किस किया है? Lady replied, हाँ किया है. Okay, when was the last kiss? Yeah, 6 months ago, because बाद में मेरा breakup हो गया. Doctor said, okay, या तो breakup को make up कर दो या कोई दूसरा boyfriend ढूंढ लो. Infection नहीं, तुम्हें जंग लग गया है. So today on this Valentine's Day, I will make this wish to your respective Valentines on behalf of you. किसी ने किसी को लंबी उम्र की दुआ दी, किसी ने किसी को लंबी उम्र की दुआ दी, किसी ने किसी को जीने की वजह दी. ऐ खुदा मेरे दिलो जान को सारे जहां को सारा जहां देना. ऐ खुदा मेरे दिलो जान को सारा जहां देना, जिसने अपने दिल में हमें थोड़ी सी जगह दी. So, and with this wish, we move on to the technical session. Today's paper is on case studies in direct taxes. Paper writer is Dr. Anita Sumanth and Chairman Shri Inamdar. Both are very learned and eminent personalities, and their worthiness and achievements are jotted in their respective profiles printed in the paper book. So I will be very brief in introduce them. Shri Inamdar is practicing as a senior advocate and is on the board of directors of various well-known companies. He has been the president of the chamber during 2002-03 and has been the chairman of many technical sessions and brain trust. Has been brain trustee also in many of our RRCs and also in other programs of chamber as well as other organizations. Our paper writer, Dr. Ms. Anita Sumanth, is an advocate and holding PhD degree awarded by the National Law School of India University, Bangalore, on the subject of international taxation, electronic commerce. She has participated in various interactive programs at international and national levels and has been chairperson of various legal bodies, committees, and committees of Chamber of Commerce. Friends, I think many of you were present during the brain trust session which was held in the RRC held in Kadao, Calicut, and we had brain trustee Shri Ramchandran, and we were all almost mesmerized by the wise clarity of thought. Let me just share with you. Ms. Anita is the daughter of Shri Ramchandran. So we also expect the same thing from you, madam. Before we start, I think I just ask Shri Parimal Bhai to do a moment of Shri SNM Inamdar sir. May I request our past president Sujal Shah to come forward and present a moment or two of our paper writer, Dr. Anita Sumanth. Now hand over to the chairman of today's session, Inamdar sir.
Thank you for your kind and handsome words, Maharaj. But even often that I can sit there and talk. But being a lawyer, I don't believe that anybody listen to me. I just stand up and talk. Much was said about the red. Whenever I see red, I am accustomed to stop. You want me to continue? Actually, I would prefer to give my opening remarks before the group discussion started. Now there is no point in wasting time on that. She is ready for her explanations. But since something was said about Valentine's Day, I will give you only one advice on the Valentine's Day. That marriage is an investment which pays dividends if you pay interest. I would request Dr. Sumanth to make her reply to me. Thereafter I will make submission. Thank you.
Good morning, ladies and gentlemen. I must say that Mr. Bhavish has put me on a very unfair footing to begin with. He mentioned that my late revered father was a brain trustee and then said, we expect the same from you. I would say that I have a long, long way to go before we can reach the standards that the earlier generation set. And in fact, I must thank the Chamber today for giving me an opportunity to be part of this course, because I am looking at it as much as a learning experience as all of you here, and hope to go back sufficiently enriched. On the question of Valentine's, except for I think a few lucky people here, all of us have left our Valentines back at home. But being the professionals that we are, we have an advantage. We have one Valentine at home and one at work. And as far as I am concerned, this would be my Valentine for the day. The way I thought we could structure this session was, I will summarize the facts in regard to each of the case studies and give you my thoughts with respect to the issues that I thought emanate out of it. Of course, I I have only scratched the surface in most of the issues, and in the course of the group discussions with the group heads, I found that there are a lot of interesting thoughts that have been generated amongst the members of the groups itself. So then at the end of each case study, I would, with the permission of the chairman, open the floor for 2 questions, and I would request that the group leaders ask these questions to cover any of those aspects that I have not covered in the course of my presentation. I hope that's okay. Now moving on to the first case study. I must confess that many of these case studies have a bearing on my own experiences, either in terms of issues that I have had the benefit of dealing with in the past, or issues that are currently topical and live before various fora. Now, as far as the first issue is concerned, we have the case of a trust that is registered as a charitable trust, that is admittedly engaged in the activities of furtherance of education and medical relief. There is no dispute that the objects of the trust are not charitable in nature. This trust has been granted registration under 12A as early as in 1982, and it is clearly essential in terms of Section 11 of the Act, which has also been consistently granted to it. We find that in April 2010, the Commissioner of Income Tax has issued a notice proposing to cancel registration, invoking powers under 12A(3). By way of a brief background, as you are all aware, 12A(3) was introduced, granting powers to the Commissioner to cancel registrations granted under 12A. Initially, the power granted to the Commissioner pertained only to those registrations that had been granted after 1996, under 12A as it stood after 1996. Realizing a lacune, in 2010, another limb was introduced to subsection 3 of 12A, granting powers to the Commissioner to also withdraw or cancel registrations in respect of those registrations granted under 12A as it stood prior to 1996. So in April 2010, we have the Commissioner taking proceedings for cancellation of registration in respect of a trust that had been granted registration in 1982. So prima facie, on a comparison of the dates, we find that in April 2010, when this Commissioner initiates the action, there was no sanction under 12A for him to have undertaken this action. The matter travelled to the tribunal in appeal, and the tribunal confirms it. As far as the facts before you are concerned, that matter is pending in appeal before the High Court under 260A of the Act. Now, parallelly, assessments are taken up for completion and claim under Section 11 is being examined. In the course of assessment, the assessing authority finds that quite apart from the absence of a career registration certificate, which is mandatory for a claim under Section 11, the trust also runs institutions where, according to him, capitation fee has been received. According to him, the generation of income by way of capitation fee militates against charitable purpose as set out under 215 of the Act, and he thus rejects the claim for extension on the dual grounds. The third issue that I have pointed out is, while completing the assessments, he says, I am granting depreciation now. However, if it is found later that 12A, 11, etc. is to be granted to this SSC, then depreciation is to be withdrawn, because aggregation of funds has already been there, and therefore it would amount to a dual benefit in the hands of the SSC. Now, the issues that I have raised for your consideration are: 1. Are the provisions of 12A(3) retrospective or prospective, both with effect to the first limb and the second limb set out under subsection 3 of 12A, that is, with respect to registrations granted pre-1996 as well as post-1996. Now, this issue, if you look at the slew of case law that we have on this subject, courts, most courts at least, have taken the view that the provisions of 12AA3 are not retrospective. Now, I must in this context refer to the division bench judgment of the Bombay High Court in Singahat Technical Education Society versus CIT, reported in 343 ITR 23. Now, there are two important observations that have been made by the division bench in this case. The bench says, quote, a law which operates with respect to an event which has occurred in the past is not necessarily retrospective. Now, the facts in Singahat are this. Even in that case, proceedings were initiated prior to 1/10/2010, 1/6/2010, when the power to cancel registration was inserted in the Act. The action of the Commissioner was challenged in appeal, and the tribunal allows the SSC's appeal, holding that power was not available as on the date when the Commissioner takes the action. The revenue is in appeal before the High Court. In the meantime, what happens is the law is amended, and power is included in subsection 3 of 12AA. Therefore, when a show cause notice is issued by the Commissioner, the constitutionality of 12AA3 is challenged by the SSC before the Bombay High Court, holding that the provision itself is ultra vires the Constitution. While deciding on the aspect of constitutionality, the division bench says, upholding the constitutionality, the line that I have just now said, that merely because an act is done today to invalidate a prior act does not mean that it is retrospective in nature. Therefore, the sum and substance or the rationale that one would arrive at in the context of this judgment is 12AA3 would have to be tested in the context of the conditions mentioned in 12AA3 itself. Now, the section says the Commissioner has power to cancel registration if it is found that the activities are non-genuine or are not relatable to the objects of the trust. And therefore, if the Commissioner today finds that the activities are non-genuine or are not relatable to the objects of the trust, he would have the power or the authority under 12AA3 to cancel the registration. Of course, one issue that arises in this context is, suppose the cancellation is done mid-year. The validity of the 12AA3 order is one thing, but in completion of assessments under section 11, you may be looking at two different periods. You may be looking at a period when the Commissioner has the power after 1/6/2010 and prior to 1/6/2010 as in the present case, when he was not vested with the power. Between April and June of 2010, there was no power in the Act. Pursuant to June of 2010, he acquires the power that is vested by statute. So that becomes an additional issue to consider. Now, the judgment of the Bombay High Court has also been considered by the Madras High Court in an unreported decision in the case of Shri Trust. In fact, this judgment is available in a soft copy with me, and I will circulate it to the organizers for onward transmission to you, where the Madras High Court has said, yes, we agree that this is not really the question of retrospectivity. You are looking at an act today and testing that act in the light of the conditions that are contained in that statutory provision. However, while doing it, you may invalidate something that has happened earlier, but the question before you is not whether it is retrospective or not. You are applying the law with the conditions as of date. So that's an important question that will have repercussion, because some of the group leaders mentioned that this issue of retrospectivity has also been raised by the members in the context of is it clarificatory, etc. All that may not be very relevant now, because you are not really testing the retrospectivity of the act, of the section at all. You are only testing the application of the section today on the basis of the conditions set out in that section itself. Now, one more important observation that was made by the Bombay High Court in this judgment is, at page 29, they say, quote, this section does not create new obligations in respect of past actions. Now, this sentence is again a loaded sentence. What does it mean? If it does not create a new obligation in respect of past action, that cancellation is operative only from today. So the operation of that cannot be rewound to say that I will reopen your assessments for past years, etc., because your objects have been found to be non-genuine or your activities are non-relatable to the objects. That will hold good only from the date of cancellation. Now this becomes relevant because we have batches of matters that are pending before the High Courts both at Madurai as well as in Chennai, challenging notices under 148 that have happened pursuant to cancellation of registration by the Commissioner, holding that since the Commissioner has held that your 12 days to be cancelled, your activities are non-genuine and they are not in tandem with the objects. So this may have some relevance in that context. Again, there is an important decision of the Madras High Court in the case of CIT versus Sarvodaya Ilakya Panne, which is reported in 343 ITR 300, which takes into account this specific aspect that cancellation has to be seen only with respect to whether the Commissioner has recorded his satisfaction that the activities are non-genuine or that they are not relatable to the objects of the trust. If there is no satisfaction that is recorded by the Commissioner, then the cancellation would have to fail. Again, a recent judgment of the Madras High Court in the case of Tamil Nadu Cricket Association versus Director of Income Tax Exemptions. I will circulate a soft copy to the organizers. You are all aware that as far as Gujarat and other jurisdictions are concerned, the Income Tax Appellate Tribunal itself has accepted the plea of various similarly placed associations that they are entitled to 12A registration. The Madras bench of the Income Tax Appellate Tribunal took a different view on the ground that you are not carrying on any charitable activity, you are engaged in high-flying activities like IPL, etc., which generate huge income. What is the charity that you do? At best, you may be considered an entertainment, part of the entertainment industry, etc. When this matter travelled to the High Court, the order of the tribunal was reversed, and more importantly, an important ratio that was laid down was that you have to test this in the context of 215, 2 subclause 15 of the Act, as it stood when the registration was granted to you. Now, why does this assume importance? 2 subclause 15 was amended whereunder the 4th limb of charitable purpose, which is objects of general public utility, was whittled down to a great extent. Therefore, after the amendment in 2009, what remains as a charitable purpose is education, medical relief, and relief of the poor. At the time when the Tamil Nadu Cricket Association was granted registration, there was no such restriction. 250 stood in all its width and in all its glory. Therefore, what the High Court has said is, yes, it may be engaged in objects of general public utility, but you have to see what is charitable purpose at the time when the registration was granted, not at the time when you are looking to cancel it today. This is a very important aspect, and the High Court has not given a blanket direction. They have said, if you are of the view that the activities of the TNCA do not merit an exemption under Section 11, that's a matter for assessment. That is not a matter for 12A cancellation in any event. Now, this distinction between grant of registration under 12A and claim of exemption under 11 has been looked at by the Supreme Court in the case of American Hotel Association, and in fact it was also referred to by one of the group heads this morning. 12AA will have to be tested simply on the strength of the conditions set out in subsection 3. Whereas, if you are of the view that the assessee is not entitled for 11, look at it in the context of assessment alone. Now, some of the issues that were raised by the groups were, before moving to that, we will also see depreciation. Depreciation is consistently claimed by all trusts that are engaged in business activities as well, insofar as 11(4)(a) permits a charitable entity to carry on business activities in order to fuel its charitable purposes. Now you are all aware of the background to the insertion of 4A to subsection 11. The Supreme Court and Country Trust deals with this in detail. And what they say is, charity is very good. One has to engage in charity, but charity requires the generation of funds as well. One has to feed the charity, as they call it. And where does one get the fuel to carry on charitable activities? Either the charitable institution could itself generate the funds, which is sometimes difficult for a charitable institution to do, or you could have it carry on a business activity along normal commercial lines. The income wherefrom is plowed back for the achievement of your charitable objects. 11(4)(a) permits this, except that the conditions laid out are that I should maintain a separate book of account in respect of my commercial activity and in respect of the charitable activity. This is to ensure that there is a possibility to monitor that whatever is the income from my non-charitable activity is actually utilized only for the attainment of my objects. Therefore, when I carry on a business or I have assets for the charitable institution itself, normal commercial principles of computation of income are applied and depreciation is claimed. This has been a consistent position from day one as far as section 11 is concerned. We have in fact all the judgments that I have outlined here. Bombay High Court, Madras High Court has not given a judgment specifically on depreciation, but an old Madras High Court judgment in the case of Kalavarakal and charities has looked into what are the principles that would apply in determining the income of a trust. Suddenly, the Kerala High Court takes a different view in the case of busy medical institutions. The basis of the Kerala High Court's judgment is that there is a Supreme Court judgment in the case of escorts, where the Supreme Court says in the context of section 35, they say that you are not entitled to a double claim, and therefore applying that rationale, the Kerala High Court takes the view that you have already got the benefit of application of funds. And having got the benefit of application of funds, to claim depreciation also would amount to a double benefit. In fact, the judgment of the Kerala High Court makes a very, very interesting reading. They say all trusts are seeking application of income, claiming section 11 exemption. They are also claiming depreciation on the assets owned by them. Logically, the division bench says, whatever is the depreciation that you have claimed, you should write back, they say. And if you don't write back this depreciation, this was the shocking turn of phrase used by the division bench. They say it amounts to black money in the hands of the trust. And they say it is amazing to see that for so many years, so many charitable institutions have been seeking application as well as depreciation. Just think of the amount of black money that is available to all these institutions, they say. So having said that, what the division bench does is, they seek an opinion from the CBDT. That is sometimes done, as you know, in the course of hearings. They tell the standing counsel to get an opinion from the CBDT on this specific position in law. And the CBDT was very happy that they have found a division bench that would take such a view. So immediately they write back a note saying, yes, we have gone into this issue and we find that it's a very unfair thing that these trusts are doing. They are all claiming application, they are all claiming exemption under 11, they are all claiming depreciation also. Just imagine the unfairness of it all. And based on that opinion, the Kerala High Court has come to a conclusion that escorts will apply and that depreciation is not available in respect of assets utilized by a trust. Now they also recognize the position that it is a consistent position from 1961. And therefore they say, since this assessee may have been claiming depreciation all these years, we will not disturb it for the earlier years. From this year going forward, they should not do it. Whatever is the depreciation they have claimed for the current year and previous years, please write it back and make a claim for setting this off against application for later years. That is the sum and substance of the Kerala High Court judgment. This is the only judgment making an appeal before the Supreme Court as well. It should be admitted for the reason that the plethora of judgments on this point is clearly in favor of the SSC. Because if there is a particular computational methodology that the Act permits me, the Act permits me to claim application and the Act permits me to claim depreciation. In fact, if you see the Madras High Court judgment in the case of Kalwala and Charities, it's very beautifully put there. I think I've cited that here. Yes, 135 ITR 485. They say that in cases where the Act or the department requires that your computation of income should be as per the methodology given in the Act, they stipulate in that section. They say computation as per the methodology set out in the provisions of the Act. 11 contains no such stipulation at all. Therefore, the assumption is that one can apply normal commercial principles, and this is allowed in the absence of any restriction in the Act. Now, we will just go to the questions raised by the group heads this morning. The first one was, we are talking about the Prohibition of Capitation Fee Act. This is a different enactment. And as far as the provisions of this enactment are concerned, yes, the collection of capitation fee may be contrary to law. But how does this impact an assessment in terms of the Income Tax Act, which is a separate enactment by itself? See, my opinion here is that capitation fee is clearly relatable to the activity of education. If you look at the Supreme Court judgments in the context of education itself, P.A. Inamdar's case, Unikrishna's case, Islamic Society's case, these are the cases that lay down the proposition that the collection of capitation fee for the furtherance of education is not an activity that is permitted by law. Of course, Mr. Inamdar also pointed out yesterday that the Prohibition of Capitation Fee Act is itself a state act. Therefore, what is capitation fee? What is the methodology to be adopted in collection of capitation fee may vary from state to state. But when I think about it, I wonder whether this would impact the treatment for the purposes of income tax. Why do I say this? If 215 says that charitable purpose concerns the activity of education, it means the conduct of the activity of education in a lawful manner. Where does the Income Tax Act say this? It does not say this anywhere. But that is implied in the fact that the activity mentioned is the activity of furtherance of education. Which means that if the law of the land requires that I carry out education, the dispensation of education in a particular manner, I have to keep to that. So my response to the first question would be, is the fact that another law has been violated, does it have any impact on my assessment? It may have an impact on assessment. In fact, we have seen various judgments from Tamil Nadu and other jurisdictions as well, where they say that if you are engaged in collection of capitation fee, then it disentitles you to a claim of exemption under Section 11 because the activity is a prohibited activity. That is one. Second is, the question was also raised on the connection between the amendment to Section 215 and 12A83. That is, does the fact that objects of general public utility has been whittled down in 215 have any repercussion on 12A83 per se? I think this question has been answered by the Madras High Court in Tamil Nadu Cricket Association, where they say that you have to test it at the time when the registration was granted to you under 12A. So at the time when 12A registration was granted to an SSC, if 215 stood in a particular form, that is the form that will have to be looked into to determine this. The third question that was asked on, again, feeling of charity that I think I have already dealt with. Just one incident that I wanted to mention here is, in the context of 11.4a itself, We were arguing the matters pertaining to a claim of exemption under Section 11 by Kalyana Mandapams before the Madras High Court. And the division bench, when they were hearing these matters, were looking into 11.4a, what are the kind of business activities that are permissible? Can I carry on any business? That may also have a repercussion on the earlier aspect of a law, whether it is in violation of general law, etc. Suppose the bench posed this question to us. Suppose I carry on liquor business. Can you say that the income from this liquor business is also entitled for exemption under Section 11? In fact, this specific question was posed by Justice Ibrahim Khalifullah when he was looking at Kalyana Mandapam, because this trust that runs the Kalyana Mandapam was also having activities of horse racing. So he said, what is this? How can you say that horse racing, liquor, etc. are legitimate business interests? Can you say that these business interests can generate income that are exempt under Section 11? So the response was, why not? Why not? If it is proved that I maintain a separate book of account, and if it is proved that that income is utilized for the attainment of my objects, that is all that 11.4a requires. So I come to the end of my synopsis on case study 1. We will take just 2 questions. If there is any aspect that has not been covered. No? Should I go ahead?
Madam, on depreciation, recently GVK Charities, Bombay High Court has decided after this Kerala High Court judgment that depreciation is allowable deduction along with the application claim also. It is thereafter this recent judgment has been.
Thank you for that. And they have also followed the Institute of Banking, which is the earlier Bombay High Court. That is why I said the only judgment that takes a different view is Kerala.
But department is not accepting that. All everywhere the additions are made on depreciation. We have seen they are in Supreme Court.
That's right. And not only does the department not accept it, in all cases of ongoing assessments, now they are taking the view that the CBDT has expressed an opinion in the course of resident medical institutions. Therefore, we are going to take that as the view of the CBDT. So what they are doing is, as far as the opinion given to the Kerala High Court is concerned, they are giving this opinion a status of a circular under 119 and making it binding on themselves, which is in fact the unfortunate outcome of this entire proceeding. One more question.
Depreciation should be one of our members has told. He is informed us that depreciation to be given under section 56 or 57 and not under section 32, but you said it has to be covered under section 11 before that. So just background.
When one claims depreciation in respect, the point raised by the Kerala High Court is, whatever it may be, you get a double benefit. And you are not entitled to that double benefit. Whatever your claim might be in terms of, if you get a double benefit, the Kerala High Court says you are not entitled to that. So you are only on that position. Once you compute it on normal commercial principles, then I am entitled to vote. My claim may be under whatever it may be, but I am entitled to vote. Shall we move on, sir? Sir, I think I have been given the mandate that we cannot go beyond 2 questions. The second case study. We have an entity that is engaged in development and management of infrastructure facilities. Now, 80IA 4, this is concerned primarily with the interpretation of 80IA 4 that deals with an infrastructural facility. As you are all aware, the phrase infrastructural facility has been defined in the explanation itself. And if you see the nature of activities that are covered under the explanation, you are looking at a road which includes a toll road, you are looking at a highway, port, airport, water treatment plant, etc. All of them are activities that engage significantly the participation of the government. Therefore, you have an infrastructural facility which is more or less envisaged to be carried out in participation with the government or a government authority like the Toll Board or the PWD or the National Highways Authority. And then you have an explanation to 80IA 4 which says that this explanation was first inserted in 2004 and the present one substituted it in 2009. It says that if this work is in the nature of a works contract, whether it is awarded by the state government or the central government, then you are not entitled to the benefit of ETLE. Now this raises a whole gamut of issues for resolution. Now first is, there are two key elements in this explanation. One is, it talks about a works contract. If you see what a works contract is, it is not defined for the purposes of income tax. A works contract is defined for the purposes of VAT, for the purposes of sales tax. A common man understands the works contract as being a works contract, his own definition of what a works contract might be. But for purposes of 80IA4, we do not know what a works contract is. So one will have to understand what a works contract is in the context of what an infrastructural facility is and what the scheme of 80IA4 itself is. Now, the scheme of 80IA4 is to grant a benefit to those entities that undertake to develop or execute infrastructural facilities that the government does not do on its own. Now, if you see the explanatory memorandum to the 2007 insertion, it says that this will cover those situations with entrepreneurial and investment risk, but not only business risk. Therefore, if an entity takes only a business risk, he becomes a works contractor. If he takes up entrepreneurial as well as investment risk, then he is protected. Again, these are all words that would have to be interpreted keeping in view the facts of each particular case. Now, if you look at the two projects that we have here, one is an overpass in the state of Kerala, the second is two roads. Now, the explanation to 80IA4 says a road, including a toll road, is entitled to be called an infrastructure facility. I am answering both the issues raised by me in tandem together because I feel that one flows from the other. If you are taking the view that any road is to be called an infrastructural facility, is a 1 kilometer road also an infrastructural facility, or would you say that it has to be in terms of proportion? A 100 kilometers road that has 5 toll booths on it, is that an infrastructural facility? Now the CBDT has issued a circular. I am taking the specific example of a road because the CBDT has issued a circular in the context of road, saying that building of a new road is an infrastructural facility. It also indicates application of mind by the CBDT because they further clarify to say that if you merely relay a road or if you repair a road, then that is not an infrastructural facility. But if you add to a road, if I make new lanes, if I make a 6-lane road and 8-lane road, or if I lay a new road itself, but it does not clarify the position as to whether a 1 kilometer road is also deemed to be an infrastructural facility. Therefore, what are the parameters to decide what is the width of the term infrastructural facility? If one were to read it on an apparent reading of the section combined with the clarification given by the CBDT, if I build a road from this hotel connecting it to the main road, that is sufficient. It is a new road and it is an infrastructural facility. One important point that was made by all of the participants yesterday in the course of discussion was also this. The purpose behind an infrastructural facility is to bring development to a certain part of the country. Now this is a very, very relative thing. Sitting in Chennai with the paucity of water, if there is a mega plant for desalination that is put up, for me it becomes an infrastructural facility. Sitting in some interior part of India, where again there is a scarcity of water, digging of an adequate well is an infrastructural facility. Therefore, this is something that is also very relevant to be seen in the context of location of the facility. There can be no hard and fast rule to determine what is an infrastructural facility that would qualify for ETIA benefit. Now we had matters before the tribunal and before the courts where this question of, you are talking about a small road, Anita, which connects one place be called, he is not called a works contractor for the purpose of this. If you look at a PWD contract, a mere PWD contract, he is awarded a small work and he carries out that work. But in all these contracts, you will find that there is a performance guarantee that is given. So there is a certain proportion of risk that he also carries. However small the contract may be, that contractor also carries a certain proportion of risk in proportion or commensurate with the scope of work under that contract. He also has the risk of ensuring that whatever it is, whatever is it, that facility that he has made is a workable facility that works well for the purpose for which it has been carried out. So these are issues that have not been decided one way or the other. We have, of course, the third member decision of the Bombay Tribunal in the case of E.T. Patel, but that, as well as the Bombay High Court judgment in the case of ABG. To the best of my knowledge, the Bombay High Court judgment in ABG is the only High Court judgment that is available today. ABG Heavy Industries, 322 ITR, page 323. This was on a slightly different connotation before, because it dealt with the provisions of ADIA 4 prior to the amendment. Prior to the amendment, the scope of work dealt with development, A, B, operation and maintenance, C, developing, operating, maintaining. After the amendment, what happened was, there was an or that was added to these words. Therefore, it read A, developing or, B, operating and maintaining or, C, developing, operating and maintaining. Therefore, the question that arose was, is this retrospective? For years 2001, 2 and 2, 3, when the or was not there in the statutory provision, the department took the view that, no, you have to be a developer. Unless you develop, you are not entitled to ATIA. If you merely operate and maintain, that is not sufficient. The SSC sought to take the benefit of the insertion of the word or to say that it is only clarificatory. Here, the provision is very clear to say that I could be engaged in one or the other of the activities. And this view was accepted by the Bombay High Court to say that it is only intended to clarify that I don't have to be a developer. I can merely execute the contract, I can operate the contract, I can maintain the facility, and that is sufficient. That doesn't answer the issues that I raised earlier as to what is the width of infrastructure facility, what is the width or the interpretation to be given to the term works contract. One other confusion that may be added to this is the use of the word owner. Owner of the enterprise, as was pointed out. Owner of the enterprise is who is entitled to this facility. So if one sees a cumulative reading of all these terms, how would one arrive at a conclusion as to whether the benefit is available or not? I would only want to say that it is largely fact-based. One thought is it intended to restrict the benefit to only the first line of contractors and not to subcontractors? That may be one methodology. If you look at the Madras Tribunal decision in the case of indwell linings, I have cited it here, 122 TTJ 137. Here the scope of work pertained to coating of certain pipes. The main contractor was given the job of laying the pipelines. Thereafter, the main contractor subcontracted it to indwell linings to coat the surface of the inner surface of the pipes with certain anti-corrosive material. Indwell linings claimed ATIA with respect to the income earned by them for their project. The main contractor claimed with respect to his portion of the work. But the department said no. You are only a works contractor. Your scope of work is so small, it would not qualify for relief under section ATIA. So that is one issue that we have. The Hyderabad bench of the Income Tax Appellate Tribunal has, in the case of Koya and Company Construction, also looked at the issue that we are now dealing with. if one breaks it down, the tribal's view is based on the fact that design, development, operation and maintenance, liability period, performance period, financial involvement, these are all some of the parameters that have been laid down by the tribunal. If all these are there, as far as the contract is concerned, you may have a good case to argue saying that my exposure as far as the contract is concerned, not just a financial exposure, but my involvement and the participation in that is sufficient to entitle me to the benefit of ADID. One issue that was raised is in the context of ADID 10, which talks of developer. Can the judgments in ADID 10, can the import of those judgments be encapsulated to ADID 4 as well? Why not? One is looking at the word developer. And when one looks at the term developer, as the explanatory memorandum has been self-stated, you're looking at somebody who bears the risk of an entrepreneur and investment. But there will be one caveat here. As far as a developer is concerned, he's a private party that enters into a transaction with a private party. If you look at an infrastructure facility, invariably the other party to the transaction is the government. And many of the projects that I execute or I operate or I maintain is not a project that is envisioned by me. It is a project for which the government has a vision and I am called in to execute the project. Does that make me any less of a developer, any less of an entity eligible to claim 1884? Any two questions that we will take on this. Shall we move? You don't have to carry it forward, you can set it off right now.
Unless it is carried forward, it cannot be sued.
I have determined. The third one is, we have a factual scenario where there is a company that is formed by two separate and distinct entities. They own an asset. The entities decide that they would like to demerge this asset for various administrative and logistical reasons. One of the benefits that happens at the end of the entire sequence of events that has been set out here is that they get a relief from dividend distribution tax. And I set it out as a poser because I want the sequence to be taken to its logical conclusion in order to discuss the issues that I raised. So they approached the respective jurisdictional high court for sanction of a scheme of demerger. The effective date is a date prior to 2016, so GAR should not be applicable. And this scheme is entered into after taking into account the requirements of both the companies. Now, you could possibly tweak this slightly in order to ensure that the justification for the demerger is made very apparent. Because one issue that was raised in the morning was, I think everybody was unanimous in their conclusion that what you need to ensure is a commercial justification for the demerger. Now, if a commercial justification for this demerger is necessary, one would have to ensure that the respective boards pass resolutions and they say that this is the reason why we want the demerger to go through. If on a different set of facts, we had an experience where there were families, and the families wanted to split the asset. In which case we said we'll raise the dispute, refer it to arbitration. You have a high court judge or somebody respectable sitting on the dispute to adjudicate upon the dispute, pass an award. That becomes an award that is acceptable to both parties, and this gives it some sanctity. On the basis of this, you apply for a demerger. So what is very important is to put the clock back and ensure that whatever has to be done in terms of justifying this transaction is ensured right from stage one. If it is two companies, you will ensure that their business activities are such that they can carry on these businesses separately. The resolutions are passed, they are approved, and then a scheme is entered into which takes note of this position. Now, in the context of the facts that I have laid out, the first question that I have raised is 47(6)(b) says any transfer in a demerger of a capital asset by the demerged company to the resulting company if the resulting company is an Indian company. It says is an Indian company. Now the question in the facts, once there is a demerger, these two resulting companies change status to a limited liability partnership. This is again to ensure the achievement of the final goal being DDT, not being taxable in their hands. Now in such a scenario, is there an opening for the assessing officer to say that 6B is available only if the status of the resulting company as a company remains so for any particular length of time? Now, on an apparent reading of the provisions of the Act, there is no such restriction. There are provisions that say that if the conditions are not satisfied, then you lose your status under 219 as a legal demerger itself, and that could get hit. But as far as this is concerned, none of the applicable provisions have a clause to this effect. The only thing is, if the effective date is say the 1st of January for a particular year, then for part of the year I have the status as a company, and for the remaining period I have the status as an LLP. Can the assessing officer read a condition into this saying that the resulting company should be an Indian company at least for that relevant financial year? Is there such an opening? That was the thought that occurred, and I think unanimously it was felt that there is no restriction of any sort as far as the change of status is concerned. And the two companies would be free to change their status. It is only the date of High Court order which probably would be the relevant thing. One could say that it is in fact the effective date. The status has to be seen as of the effective date, but I would go a step further and say, as of the date of High Court order, one should ensure that the company is an Indian company. Second would be the more important issue of, in the case of the entities, exemption sought in terms of 47(13) was rejected on the ground that the transaction of conversion to LLP and the resulting claim of exemption from capital gains was colorable, designed solely to avoid the impact of DDT. Now, one interesting point that was raised in the discussions this morning was that why should it be colorable? You are looking at it in isolation only from the viewpoint of DDT. But this is in fact a business reorganization that has been done. So if you are looking at it as a business reorganization, the scales would be both ways. I may have a benefit as far as DDT is concerned. I may have certain trade-offs in other areas that may not be to my advantage. So if you are looking at it in the holistic context of a business reorganization, then the allegation that it is colorable would fail at the threshold. This, of course, would have to be seen in conjunction with what we discussed earlier, being the paperwork and the documentation relating to the scheme and the entire sequence of events being such that there is absolutely no doubt that can be raised on this score. The case law that came out in the course of discussion was also all for shares and Azadi Bachao Andolan, quite apart from the Vodafone judgment that we have, that has sort of laid the last word on what would be a colorable exercise of power after going into metaverse, etc., etc. So the position would be, if one looks at the transaction, if it is permissible within the four corners of law, then there really exists no justification to say that it is an abuse of the legal process or that it is colorable in nature. Again, as I mentioned here, the provisions of GAR were mentioned. As of now, we are protected from the GAR, which we anticipate will come in 2016. So we should ensure that to have your effective date much prior to that. That's the only protection that you can have as far as GAR is concerned. Any questions on this? Case study 4. Here we have a situation where agricultural lands were owned by an individual. The important issue here is that one looks at 214, you are looking at a capital asset which is agricultural land, simpliciter. Nowhere in the Act is the phrase agricultural land defined, and therefore we look at the import of judgments to help us understand what would be agricultural land to ensure that you have the benefits set out under the Act. Now, one point that was made this morning was that in India, all lands are agricultural except those that are rezoned to call them urban lands. Assuming for a minute that this is true, would it then mean that now if you look at the notifications that we have in various states, these notifications are all ancient notifications that have not taken into account developmental activity at all. So if you look at Chennai itself, you are now sitting in Pondicherry, you know that you have the old Mahabalipuram road. OMR is now called the IT corridor, but it has not been included in the circular to bring it within the ambit of non-agricultural. Of course, with the amendment now it comes in, but the position prior to 2013, when the distance was still 8 kilometers, many of the properties in OMR were still getting away with the term agricultural lands, even though I don't think, let alone agriculture, you don't even have a single plant or tree growing in most of these places, because it is simply a concrete jungle that you have there. But still, many of the sellers that were visionary enough to purchase large land holdings earlier made a killing when they transferred these lands simply because of the benefit that the section gave them. And it is primarily in this context that this issue has assumed a lot of significance now. I also understand that in Haryana, you have a similar problem where you have a similar issue coming up, where earlier lands that were agricultural in nature, which are being developed today, are being sold, and the issue is whether they are entitled to the exemption provided or not. Therefore, if we have to look primarily at judge-made law to decide whether it is agricultural or not, I refer to two judgments here, Sarifa Giri Mohammed and Court of Botswana. They set out various parameters, but one recurring theme that is there in all these judgments is the land should be put to use for agriculture. The tribunals and high courts have been taking a view that the putting to use of the land for agriculture is paramount as far as the claim is concerned. When I say put to use, we have had instances where, in order to ensure that the agricultural nature of the land is maintained, nominal income from agriculture is returned every year in the returns. Is this sufficient? People have been getting away with it by saying that for these assessment years, if you look at my returns of income, you will find that there is some agricultural income that is returned. And therefore, that is sufficient to show that the nature of land is agriculture. Of course, apart from this, you need to have a village administrative officer's certificate or the equivalent in each state. Whoever is the Tahsildar or the VAO or whatever is the authority in the respective state who gives a certificate saying that these are all wetlands. These are not dry lands. And one important distinction that has been made in cases is some VAO gives certificate saying capable of cultivation. We are not concerned with the inherent nature to be capable of cultivation. The assessing authority wants to see that it is in fact cultivated. Therefore, when the VAO gives a certificate, it is important to vet the wording and ensure that he doesn't say that it is capable of cultivation, but he says it is under cultivation and this owner in whose hands this land stands has actually cultivated X, Y, Z, ragi, whatever it is, these crops, these trees. That is an important aspect. But the trend, at least in the judgments that I have seen today are that courts are not satisfied with merely the documentation. They are looking beyond the documentation. They are not happy simply seeing the returns of income to see that there is agricultural income return. They are not happy seeing just a VAO certificate or the payment of KIST, which is land tax or land cess, or the entry in the article, which shows that this is in fact a wetland. They are going beyond that to see whether this is a method of getting over the ground reality that you have today. And how do they do that? The trigger for this case of offense is a recent decision of the Madras Tribunal, where our Vice President here looked into similar lands in Old Mahabalipuram Road, and he says, yes, all this is okay. I have a report from the inspector that says that there is frantic construction of various IT parks around this area. And I also find that there are returns showing nominal agricultural income, but for 2-3 years in between, there is no income at all. How does one reconcile all this? So, the sum and substance of his conclusion is that your income from agriculture is negligible. The landscape of that place is a concrete jungle. It is not a place where you would carry on agricultural activity, and therefore, I am taking the view that this is not agricultural land at all, and all these documents, and that is the case where all the documents were produced. In spite of all those documents, he said, no, this is just an eyewash. It is not agricultural land as intended by statute. Now, one important point that came up this morning, a very good point that we will use, is that every land has a resting period. You cannot cultivate land year on year on year and expect it to have a return. Therefore, you have to, but of course, that is the point that will have to be put forth technically. One will have to say that it is under cultivation for the last 10 years and probably bring in expert evidence to show that in this nature of land, in the area in which it is, the kind of crops that have been growing, this land requires to be rested for a particular period, which is why in those 2 years you find a gap. I do not have agricultural income. That is one explanation. The second explanation is, do I have to earn income from it every year? What if the monsoons fail? What if I have been unable to attend to the cultivation in the manner in which I should have? These are all facts that could have resulted in non-yield in a particular year. So that by itself cannot be a reason to say that it is not agricultural land. So these are factors that would determine whether a land is agricultural, put to use as far as agricultural, the term agricultural is used. Now, there have been a certain small dilution in the parameters laid down by the Supreme Court. In the facts of the case that the Supreme Court was concerned with, the land had been rezoned by the seller into urban prior to sale. And the Supreme Court says as a matter of fact that the land was sold in April, the transfer happened in April, but we find that in February itself, the land had been reclassified into dry land. In such an intent, they say we should see the nature of land as on the date of transfer. So as on the date of transfer, it is dry land. But subsequently, developments in real estate as well as other that have been taken note by judgments have made two propositions clear. One is Madras High Court had occasion to consider this in the case of M.S. Srinivasan Naikar and Sons, reported in 292 ITR, where they say the use of the land by the purchaser is irrelevant to decide whether it is agricultural land in your hands or not. I may be buying it to create an infrastructure facility or to have an IT park or to promote residential or commercial buildings. My use of it as a purchaser will not prejudice or color your claim for exemption from capital gains if you are able to discharge the burden placed on you to show that primarily you have all the documentation required to show that it is agricultural, and most importantly, you have actually put it to use for agricultural purposes. One issue that was raised is you have part possession. 247 dealing with transfer, subclause 5 says any transfer in consequence of 53 of the Transfer of Property Act is also deemed
on a particular date. So in the context of times that we have today, I would think that the law would have to be read, judgments would have to be interpreted to say that at the time when possession was parted with, what is the nature of the land? If I am able to show that I parted possession, till such time I parted possession, I did engage in activity, etc., all the criteria that we have seen now, that is sufficient to show that it is agricultural land in my hands. This would also apply in a situation where, as a seller, my consideration may be part of the constructed space that the purchaser is developing or constructing. That the nature of consideration does not militate against my claim for exemption to capital gains. Case study 5. I am proceeding to the next case study. If at any point you have anything to add, please let me know. Case study 5 deals with an agreement. This is a scenario that all of us would have encountered at some time or the other, and the trigger for this case study is the recent judgment of the Supreme Court in the case of map data. 271(1)(c) contains two conditions of concealment or furnishing of collateral particulars, and it contains an explanation 1 that uses the phrase bona fide. If I am able to give an explanation that is bona fide, then I may be protected from the rigor of 271(1)(c). Now, this has always been in the past looked at in the context of